Iku Iluna, please rise. Auhea o ko e ko ka aha, inahe kuliana I mua o kea aha ho o kolo kolo ki e hano hano o ko moku aina o Hawaii. I naui mai, I malio mai, I lohe I e kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and shall be heard. Ino o hilalo. Please be seated.
Velina, greetings. Makamuku puni o Oahu I ka moku o kona e ano kako ma Aliʻiolani Hale. On the island of Oahu, in the district of Kona, we are gathered here at Aliʻiolani Hale. Please call the case.
Case number SCWC-22-0000374. Hei Ja Choi, Petitioner Appellant versus Tachibana Enterprises, LLC, and Department of Labor and Industrial Relations, Respondents, Appellees. Arguing for Petitioner, Hei Ja Choi, Lance Collins. Arguing for Respondent, Tachibana Enterprises, LLC, Jessica Sneed Wong. Argument on the merits.
Aloha kakahiaka and good morning. Today's proceeding is being broadcast live on the Judiciary's YouTube channel and on Olelo. I'd like to welcome our substitute justice in this case, Judge Karen Homa. And before we begin, I'd like to note that the petitioner is present in the audience with 2 court-appointed Korean interpreters who will be simultaneously interpreting today's oral argument. To assist the interpreters, I ask that the attorneys and members of the court speak loudly, clearly, and not too quickly. Please also avoid compound sentences, slang, and idioms. Mahalo. Counsel, are you ready to proceed? Please be seated. The court has allowed 30 minutes for each side. And just to confirm, Mr. Collins, I understand you intend to argue for 15 minutes, then reserve your remaining time for rebuttal. And Ms. Sneed Wong, you will have 30 minutes with a 1-minute warning. And before Mr. Collins begins his rebuttal, I will provide him with an opportunity to briefly confer with his client in the event there is anything she wishes to convey to him. Mr. Collins, please proceed.
Aloha, ai olo olo ai, ka'aha ho kolo kolo, kie. Aloha, and may it please the court. Our employment security law is humanitarian in purpose and ought to be liberally construed in favor of a former employee. As President Roosevelt said in 1934, before the employment security provisions of the Social Security Act were enacted, of course, unemployment insurance alone will not make necessary all relief for all people out of a major economic depression, but by maintaining purchasing power, it acts as a stabilizing device in our economic structure.
Mr. Collins, could you please lift your microphone
Sure.
and speak just a tad bit slower?
Okay. That principle animates Hawaii's unemployment statutes and rules, and it governs this case. This certiorari application presents 4 main errors. First, there was no misconduct as a matter of law under HAR 12-5-51. Alternatively, there was no substantial evidence to support certain findings necessary to establish misconduct. Third, there were language access errors on the record. And fourth, there were procedural errors by the hearings officer. HAR 12-5-21C says that misconduct requires willful or wanton disregard of the employer's interest, that it must be a deliberate violation or disregard of expected standards, or negligence so severe or recurrent to show wrongful intent or evil design. Black's dictionary defines wanton as unreasonable or maliciously risking harm while being utterly indifferent to the consequences, while willful is the voluntary and intentional but
Counsel,
not...
if I can ask you, we're familiar with the standard and we appreciate that.
Yes.
I want to ask you about the substantial evidence. It seemed to me when I read the hearings officer's decision and based on the employer's testimony that the full reason for the termination was all three reasons. That's the handbook and the two incidents, the seat change and the gold lane. Is that your understanding as well?
Yes.
All right. So if one of those gets knocked out as being found clearly erroneous, would we still have misconduct?
Well, our position is that even if you take all of what the hearings officer found to be the facts, that doesn't meet the misconduct standard. But yes, we do have issues with each of the instances that the hearings officer relied on.
Okay. And for those two incidents, the one about the counter when Ms. Choi was trying to get the seat change and the gold lane incident, was Ms. Choi given a written warning about those two incidents? Because I didn't see one in the record, and I may have overlooked it.
Your Honor, there's no evidence of any written reprimand, but all of these issues only came to light after their entire workforce had been furloughed because of the pandemic.
Okay. So after the February incidents, and I'm talking about the TSA lane and the seat change, did she engage in any other similar type of misconduct after that, assuming it was misconduct?
Well, the hearings officer made an issue about the employment manual.
No, I'm talking about those two incidents.
two
Did she violate that TSA lane restriction or get into any kind of beef about this changing a seat for a customer? Did that type of incident happen again?
It did not. It did not, Your Honor.
So
At
she
least in
wasn't
the
given
record.
so she wasn't given a warning, but it did not happen again after that.
It did not happen again, and they didn't bring it to her attention.
Well, they did on March
immediately
30th.
Right, 6 weeks after and a month after the entire workforce had been furloughed.
Right. So my question, what I wanted clarification on, I apologize that I wasn't clear, is from those two February incidents, the 17th and the 20th, in that time frame to March 30th, did she get any type of warning about not engaging in that type of conduct going forward?
I'm not aware of that in the record, Your Honor.
Okay. But the appeals officer concluded that progressive discipline was applied in this case.
Your Honor, I think the reason why the hearings officer did that
No,
was
just
that-
answer my question.
Sure.
Is that what happened? Was progressive discipline?
Yes,
That was the appeals officer's conclusion?
Yes, Your Honor. I think but also in the officer's decision, he references the 2018 incidents. But our position is that they assigned her a senior guide, and then there were no subsequent problems, and so it's not clear, like how there could be a continuity of problem where it was addressed in 2018, and then 2 years later. I think that's what the hearings officer was trying to.
Well, in the record, I didn't see anything about the substance of the complaints from 2018. Was that presented at all?
There was mention of the 2018, but it said that she had been assigned a senior guide for training, and then there was no further issue.
But as far as what the substance of the complaints
No.
were, I didn't see anything in the record, so I had no idea what it was they were complaining about.
No, and Your Honor, one of the issues about the TSA issue is actually it's not a TSA issue because TSA's jurisdiction doesn't start until the ID person. Before that, it's actually the airlines and the airport that decides. So this thing about she was violating TSA regulations, there's nothing in the record to support that. And TSA jurisdiction doesn't start till you get to the person in the uniform checking IDs. So, there's no substantial evidence to support that there were any violations of any TSA rules whatsoever. And so that issue is really a non-issue, at least the way that it was presented and at least the way the hearings officer addressed it.
Mr. Collins, with regards to whether Ms. Choi was aware of the customer complaints in February of 2020, there were two. We've talked about that briefly. One involving the TSA Gold Lane, the other involving customer service at the JAL, when a customer was trying to change their seats, right? I thought there was testimony that Ms. Choi, in response to being told about the JAL incident, had asked for video of that incident. So she was aware of that incident coming to the attention of her supervisor, wasn't she? Isn't there testimony in the hearing about that?
Yes, she asked for a copy of the video.
Right.
Of what happened.
So at what point, based on what you understand from the record, was she aware that there were these customer complaints in February of 2020?
Well, I'd like to clarify first, because although the hearings officer characterizes it as customer complaints, nothing that was actually presented in the hearings are customer complaints. One is it's either, I'm not sure if it's a security guard or if it's an airline person for the TSA checkpoint issue. It wasn't a customer who complained. It was...
Isn't JTB a customer of Tachibana?
I believe that Tachibana is a subsidiary of JTB and that the customers are the persons that Ms. Choi works for as a guide.
Well, we're going to get back to my question
Sure.
about when she became aware of it.
Sure.
But Mr. Lee testified at the hearing about the relationship between Tachibana and JTB, and his testimony indicated that Tachibana is hired by JTB to service individuals. Is that not correct?
That's correct.
Okay, so JTB is a customer of Tachibana, is it not?
I think the customers are the guests that Ms. Choi and her guides
Based on where do you point to in the record for that?
Yeah, I guess yeah, Your Honor, I guess I would say it could be characterized that JTB is the customer, but I don't. I guess based on all of the information from the two hearings, I guess I would use the word customer. I'm trying to grapple with the word customer, and I guess I don't see JTB as being. I wouldn't consider them to be a customer.
Well, let's just put it this way: the Isaro hearings officer found that they were customer complaints. I'm not sure I saw anything challenging that, but I understand what you're arguing, at least, or at least trying to argue. Let's go back to when she received notice about either of the February incidents and that customers or somebody had complained about her performance.
Right. Well, I think that maybe the distinction is that, for example, that JAL ticketing lobby issue, that, she was aware that the JAL person was embarrassed or that there was something that was out of the ordinary, but whether or not she understood that the employer had determined that she engaged in misconduct, I don't think there was any notice of that.
Do you know at what point she asked for that video of the JAL incident?
I don't have that off the top of my head, but I can
Okay,
get back to that.
thank you.
Going back to your point, you're talking about TSA and jurisdiction and so on. I don't need to get into the fine strokes on that, but I thought there was evidence that Ms. Choi had actually used that line before and had readily admitted to that when she was asked about the incident. Do you remember
Yes.
that being in the record?
Yes, and she said that I guess the airport's policy on who could use that lane had changed, and that they got training for that, or they were subsequently told that. And
Are GOAT lanes TSA lanes, or are they airline lanes?
they are airline or airport lanes. TSA's jurisdiction doesn't start till you get to the ID. They don't govern anything spatially before
Where
that.
is that in the record?
Well, that's one of the problems, that there's no substantial evidence to support the hearings officer's findings about anything regarding TSA. That's part of the problem with the TSA finding.
Well, how do you support your proposition that the hearings officer got it wrong, though?
Well, it's because there's nothing in the record to support it one way or the other.
Well, somebody had to have let her through before, right? She just didn't walk through. Someone had to have authorized her to have gone through before.
Right, and she wasn't the one that was going through. She was assisting her customers
With babies.
right, with babies to go through it.
Right.
And I mean, this is not, in the record, but it always seems like the rules at the airport are constantly changing about that. But it's the problem is that the only evidence at all related to any of this is this third-hand account of one of the Tachibana employees, that they had heard from somebody who had heard from somebody that she was trying to get this family through the
Right, but
gold
the
line.
purpose was she was trying to help her customer get through in an expedited fashion that had young kids.
That's correct. That's correct.
All right, and the undisputed testimony, at least from her, and no one discredited it, was that she had done that a number of times before.
That's correct. And
Someone had allowed her to do that.
that's correct. And Tachibana's representative said that violated TSA regulations or where it was illegal, but there's nothing in the record to indicate that that's the case. And
And there was nothing in the record that indicated that TSA made any type of complaint either. I
Well-
didn't see that.
Well, they couldn't, because they don't have jurisdiction before the ID checkpoint.
Part of that incident was Ms. Choi, at least according to the testimony of Ms. Maishiro at the hearing, was that Ms. Choi then complained to JTB about not being able to use that gold lane, and that she had the JTB staff person was upset because of the manner in which Ms. Choi was presenting that and her attitude, and that she was angry. That's the testimony of Ms. Maishiro. So it kind of goes to the relationship of Tachibana and JTB as well, doesn't it?
It does, but our position is that doesn't support a finding of willful or wanton intent. There actually just isn't enough evidence in the record to support a willful or wanton. Why was she upset? Why, part of the problem is that the evidence that was presented is sort of third hand through the Tachibana representative, as opposed to whoever the person was that was upset about it. And so we don't know.
Well, I don't know that there was any objection to how the evidence came into the record, but that is the record, that there were complaints made to Tachibana, and Ms. Maishiro testified about those incidents, right, in person.
Yes.
You mentioned willful wanton, and I'm just wondering if good intent alone is sufficient to insulate conduct that seems to work against the interests of the employer, to avoid a misconduct finding.
Well, definitely the JAL incident. I think that's something that's it's just not. Just doesn't support willful or wanton. I mean, it's like these people wanted to sit together. JL has this weird policy that people have to stand in line to do that. And then it took too long because they didn't have enough staff people. So then she goes and complains to the manager, and the manager's, is like upset that she complained. And then the customers were like, oh no, it's okay, you're doing us a favor. I mean, it just sounds like a whole bunch of nothing. That okay, she shouldn't do that, or the way that she does it shouldn't be done again. But like to get to willful or wanton.
It sounds like a bunch of nothing to you, but you're really asking us to second guess and, make factual and credibility determinations that were made by the appeals officer. I mean, the appeals officer heard from the witnesses and concluded otherwise. Isn't that what you're really asking us to do here? With that, we can't do.
Yeah, I'm not asking you to look at the credibility. What I'm saying is that there isn't enough evidence to support the willful or wanton, that what the hearings officer, the factual findings he made, does not support a willful or wanton. It doesn't require looking at credibility. I'm saying if you accept everything that has been said, that was presented, that he considered credible about the JL ticketing lobby incident, that does not support a willful or wanton finding, misconduct connected with work. If I might, I just wanted to mention two other points very briefly. I don't believe that this alone will affect something, and we're certainly not asking for a remand to have a new hearing. But we do believe that there was a fundamental language access failure in this case. HRS 321C3 says that when a language group meets 5% or 1,000-person threshold, that an agency must provide translation of vital documents and meaningful access to services. The SARO did not comply with that. The notices mailed to Ms. Choi were solely in English. They did not explain in Korean, Japanese, or any other language that she had a right to request an interpreter or translations. And at a minimum, the record should include basically standard documents informing the public of the availability of language services, and that a 91-10 notice for the contested case should be translated into the relevant language. In our view, this violates the statute. The statutory failure is also a constitutional one, in that our view is the Hawaii Constitution due process section includes a right to interpretation in quasi-judicial agency proceedings that implicate protected property interests, and that determinations should be made on the record by the adjudicator whenever it is put on notice that there is a potential language difficulty. The record does not explain why there was an interpreter mismatch between Ms. Choi's language that she submitted documents in, which was Korean, and why a Japanese interpreter was used. Our view also is that there may be an equal protection concern because limited English proficiency discrimination is a recognized form of national origin discrimination, and that there is no compelling interest or narrowly tailored action by the hearings officer to address that. And finally, the fourth error that we want to note for the court is that that there was procedural error. Under 91...
Mr. Collins, at the hearing, she requested a Japanese interpreter.
A Japanese interpreter was provided at the hearing.
Right. She requested a Japanese interpreter, not a Korean interpreter, at the hearing.
She did not request a Japanese interpreter. I believe it's the hearings officer was the one that asked for the Japanese interpreter with legal...
I see.
Yeah, with Japanese legal terms, or sorry, I have to go back and look at the record, but it's the hearings officer was the one that phoned the interpretation service and asked for a Japanese interpreter with legal training. So the procedural error is that 9110 requires the party initiating the proceeding to bear the burden of producing evidence and persuasion. And then the rules say that proceedings are to be informal, that's 12-5-93. The proceedings are to be informal, fair, and impartial. that parties and their representatives may examine and cross-examine witnesses, and that the hearings officer can assist an unrepresented party, but only where it does not interfere with impartiality, and that the hearings officer may examine witnesses, but only to the extent necessary. But what happened here is that the hearings officer repeatedly examined the employer's witnesses, even though the employer on the record said that she was representing the employer, and the questions by the hearings officer were often leading and supplied key elements of the employer's misconduct theory. And so it was not clarification, but it was case building. And it's problematic because essentially the hearings officer, to the extent that the evidence supports the misconduct finding, it was the hearings officers not complying with the rules regarding impartiality that allowed Tachibana to meet its burden, even though our view is that it didn't. And so what we're asking is that the court address this issue, but not to the extent of giving Tachibana another opportunity to present its case. It had its opportunity to present its case. It didn't make its case. But even if this court were to find that it possibly did, that the hearing officer's procedural errors are the only reason why they would have met their burden. And so on that basis, alternatively, that the finding of misconduct should not be allowed to stand, and that the decision should just be reversed and not vacated and remanded.
Counsel, if I may, did you say that you thought the hearings officer was leading?
He basically was the one conducting the examination.
In particular, you're talking about the first hearing?
Well, absolutely, the first hearing. Yeah, and what he said in the second hearing was that, is there anything in the first hearing that needs to be changed or added to? And so he relied everything on the first hearing and just added to it, supplemented it with the second hearing.
And the first hearing was the one that Ms. Choi was absent?
That's correct. That's correct. But even if she's absent, the rules say that he's only allowed to assist an unrepresented party.
I'm not trying to make a point that her
Sure,
absence
sure.
had anything to do with
Sure.
that. I actually agree with you that there was a lot of leading questions in that first hearing.
Yeah, and I think very importantly, in general, for the employment security law, that it would be very important for this court to give guidance to the hearings officer regarding that, because this seems to be a relatively routine case, and if the hearings officer is basically making the case for the employers, it goes completely against the whole purpose of the employment security law. So it would be helpful to get guidance from this court, because very few of these
Can you
cases—
speak up? Can we turn it up?
sorry.
I'm having
I'm
problems
sorry.
hearing.
Yeah, sorry. I was just saying that it would be helpful because very few of these types of cases get to the Hawaii Supreme Court, and if this is what's routinely happening in front of ISARO, it would be useful to get some guidance from the court regarding what the hearings officer should or should not be doing.
I have a factual question. At the first hearing, July 8, 2020, besides the two witnesses, a Joy Mizuno was there for the employer. Do you know if she was an attorney? I don't see her representing herself as an attorney.
She's not, but the rule says it's an attorney or other agent. The ISARO
So
rule.
why are they, say that again, sorry.
So the ISARO rule, where it says, when it describes the conduct of the hearing, it says that it could be an attorney or an other agent. It doesn't have, it's just like the PUC or other agencies that allow non-attorneys to represent corporations.
I'm sorry. So your view of that is they were represented even though she was not an attorney.
He
That's your view of
specifically
it.
said, are you representing the employer? And she said, yes, and I have two other representatives.
Right, but for purposes of your argument, I think what I'm understanding your argument to be is that essentially a self-represented litigant, that a hearings officer should be able to assist them so long as it doesn't cross impartiality bounds. But so your view is, even though there wasn't an attorney for Tachibana, because they had somebody representing the company, the hearings officer was not supposed to treat them with that same standard.
Well, Tachibana is a corporation. So if the employer isn't a human being, they have to be represented by an agent. And the rules say that if it's an attorney or an agent, that the hearings officer is not supposed to be assisting them the way they would an unrepresented party.
I'm just trying to understand your argument.
Yeah.
Thank you. Okay.
And so that, our position is that the limitation on assisting unrepresented parties means like human beings, not corporations. So, I mean, I can understand if you were a sole proprietor, you could show up and not be represented and be helped. But if you're a corporation with dozens of attorneys and stuff, I mean, the rule doesn't allow it, and I don't see a public policy supporting it that sort of companies can externalize their attorney costs onto our hearings officers to help them defeat an unemployment claim. If I could reserve the remainder of my time.
Thank you.
Thank you.
Ms. Sneed-Wong.
Good morning, Your Honors. Jessica Sneed-Wong from ESNA Inc., a law corporation, attorney for Respondent Appellee Tachibana Enterprises, LLC. The ultimate issue before the court today is whether Ms. Choi is allowed to receive unemployment insurance benefits under Hawaii Revised Statute 383 and its corresponding Hawaii administrative rules. Ultimately, Tachibana takes no position as to whether the DLIR grants Ms. Choi unemployment insurance benefits, for that is for the agency to decide. However, for this secondary appeal, as the court knows, the court must determine whether the circuit court was correct in applying the statute HRS 91-14G to the DLIR's decision. This review is qualified by the principle that the agency's decision is presumed valid, and the appellant, Ms. Choi, is the one who bears the heavy burden of making a convincing showing that the decision is invalid because it is unjust or unreasonable in its consequences. For mixed questions of law or fact, they are reviewed with deference again to the agency's decision, particularly when the applicable law is the agency's own administrative rules. For the applicable statute, HRS 383-30 Part 2, an employee will be disqualified from unemployment insurance benefits if they engage in misconduct and related to work. Under the corresponding Hawaii administrative rule, HAR 5-5E, misconduct may be found where the evidence demonstrates an employee's gross neglect of duty or willful disregard of an employer's directive. Here, Tachibana objects to and denies Ms. Choi's recitation of the facts and her various allegations against Tachibana, its business affiliates and partners, and its attorneys.
Ms. Sneed-Wong.
Yes.
Justice Devins earlier asked about a written warning. The only written warning that I saw was the one dated March 16th, 2020. Is that correct?
I believe that's the only written warning on the record of appeal. However, during the hearing, the employer noted that since 2018, Ms. Choi had engaged in conduct that resulted in customer service complaints against her,
and there were verbal
written warnings.
Verbal warnings.
Mm-hmm.
I didn't see anything about written warnings.
That was what was testified to.
And in any event, the employer at the hearing said, we're not relying on those. We weren't able to gather the information, and therefore we're only relying on these three incidents, the February 17, February 20, and the refusal to sign the acknowledgement form of the new employee handbook. Now, the written warning says, description says she refused to submit employee handbook acknowledgement, which was due on January 30th, 2020 to her manager, correct?
It was, sorry.
That's what the form says, correct?
It was originally due on January 31st, 2020.
And that's what the written warning says, correct?
Yes.
But at the hearing, the employer admitted that the email to the guides was actually not sent until February 7th, correct?
Well, what happened was that Tachibana sent out the reminder, and Ms. Choi's supervisor, Ms. Maeshiro,
The reminder being, apparently this had been posted on the website, but the email to the employee guides was not sent until February 7th, correct?
Correct. And thereafter, Ms. Choi received multiple reminders to submit the employee handbook. And as to the question I know about why the distance in time between the incidents in February and then the termination is because it took Tachibana time in order to complete its investigation into the February complaints.
Is
which
that
I'll go
part of the
into more
record?
later. It was
Is
not
that a part
as
of the record? I didn't see anything about this investigation.
it was not as part of the record because it was not brought up before Isaro, but
Okay.
I will get into that.
And in terms of the written notice, it says the follow-up date is April 14th, 2020, and it says failure basically to sign the acknowledgement by February 14th, 2020 may result in further disciplinary action up to and including termination. That's what it says on the form, but at the hearing, the Tachibana Enterprises employee said that, no, she was not told that she might be terminated if she didn't sign it by April 14th, correct?
So the hearings officer actually went over this at the hearing, as you saw. And she was told time and time again that she had to sign the employee handbook acknowledgement on.
My only question was, at the hearing, did not the Tachibana Enterprises representative testify that she was not told that if she didn't sign by this April 14th date, that she might be terminated?
I cannot recall their exact wording, but the written warning in the record states in bold in two places.
I
that
understand,
failure
that's what
to
the
abide-
written warning says, but at the testimony, she said when they met on March 16th, she was not told that she might be terminated if she did not sign. Isn't that what the representative said at the hearing?
Yes, I believe that is what the representative
And
stated.
it says
but
April 14th, correct?
it does say April 14th.
And she was terminated on March 30th, correct?
She was. However, what the notice states is that
And
any other
by
further
that
policy-
time, the state had been closed, basically, for tourism.
It had, Your Honor, but again, the handbook apologies. The written warning states that any other violations may result in discipline up to including termination. By the end of March, Tachibana completed its investigation and found, as I will go into more depth later, that she violated the rules of conduct with the February incidents and was the only employee who had failed to sign the employee handbook acknowledgement. So even though Tachibana takes no stance as to whether she receives unemployment insurance.
Wait a minute. On Ms. Choi being the only one that didn't sign, in the middle of March, there were two others that didn't sign either.
This is by the end of March.
Okay, but in the middle of March, there were two others that had not signed, right?
Yes, but by the end
Okay.
of March.
Okay, now I understand the end of March. Help me to understand how the hearings officer reconciled the fact that at the first hearing, Ms. Mizuno testified and said that the acknowledgement was actually that Ms. Choi read the handbook.
So the
And the notice itself talks about, after reviewing this handbook, please return the attached signed acknowledgement after reading. And then at the second hearing, it was changed to being an acknowledgement of receipt of the handbook only. How did the hearings officer reconcile the inconsistency in that testimony? Because the handbook acknowledgement also said, if you have any questions, go ask your supervisor, which is what Ms. Choi was trying to do. She said, hey, I was trying to get this meeting, March 16th, I went over there and they hit me with this written warning. She never got a explanation. She had questions about it. I assume it was written in English from the excerpts that I saw. My assumption is that's not her first language from what she was testifying to. So she was actually following exactly the instructions in the handbook. And then she gets hit with this warning. How did the hearings officer reconcile all of that?
I believe with how the hearings officer reconciled that is written in his opinion. So how he took it was an act of insubordination.
He
Because
just says overall. He says overall, I find it more credible, but he doesn't really pinpoint what it is. I mean, none of these inconsistencies were reconciled for us. It's hard for me to track how he got to his end result. Help me with that.
Well, I cannot speak for the Isaro's officer, for I represent Tachibana and not Isaro. But from
No,
what
from
the
your reading of the opinion.
from my reading of the
Yeah,
opinion,
I know you
it
don't,
is
I know you're not, you can't speak for the hearings officer.
from my reading opinion is because the employee acknowledgement, which was written in English as well as the handbook, because Tachibana, a multilingual and multicultural company, does business language in English because it's based in the United States. In the employee acknowledgement, the employee was signing stating they acknowledge receipt of the 2020 employee handbook. They understand the employee handbook is not a contract. They understand they are employed at will, and they understand they're responsible for carefully reading the employee handbook, and they understand that violations of the policies and procedures and requirements in the handbook may result in discipline up to including termination.
Okay, but how is she violating anything when it says you have to read the handbook first, and if you have any questions, you need to go and ask questions, which is exactly what she was doing. And then she's told, sign it as soon as possible. And the hearings officer was asking your witness, hey, was there a specific date given to her? And there was no specific date given. And then the hearings officer said, well, there's an April 14th date here. What is that?
Yes.
And then the hearings officer concludes and he says that the testimony was that she was supposed to sign by the end of the month. You remember that?
I do recall that, Your Honor.
Okay, by the end of the month was March 31st, a Tuesday. She was fired on March 30th, the day before. So she was prevented from ever reaching the last date to try and comply. Isn't that really what the evidence shows?
So, what the evidence, so again, I cannot speak to what Isaro, how it determined, but per the evidence in the record, Tachibana had an employee handbook and rules of conduct for which employees were expected to follow. And again, if they had questions, they were free to ask their supervisors questions about it. In this rules of conduct, it states that several different types of actions were prohibited, and if they were to do them, it could result in discipline up to and including termination. One of those acts is insubordination, which would include refusing to obey instructions, disregarding an order, or perform work as assigned or required, or willful neglect of duty. And per that policy, if the employee disagreed, they must still obey, and then afterwards discuss the issue with their supervisor or human resources at a later date. Also, per the rules of conduct, it states that it prohibits improper conduct that is detrimental to the company's reputation and goodwill in the community.
Let's talk about the Gold Lane incident. There seems to be some dispute as to whether or not she had previously been able to allow mothers carrying babies through the Gold Lane to go through the TSA pre-check, go through the TSA line. Apparently, she was told on this occasion that she couldn't do that. And apparently, it didn't happen again. Is that correct?
It is.
But how is that misconduct? How is that misconduct that is, if she had been doing it previously, and for some reason the regulations didn't allow that, but she was previously been allowed to do it, and letting a mother carrying a baby go through a TSA, go through a Gold Lane. By the way, is it your client's position that the Gold Lane was a TSA lane, or was it a airline lane?
It is Tachibana's position that Ms. Choi attempted to misuse a TSA Gold Lane.
TSA Gold Lane. Okay, so TSA has Gold Lanes because I've never seen them. But there's TSA Gold Lanes.
Yep, I guess things have changed since 2020. But so the reason why
I see. So it used to be TSA Gold Lanes.
Personally, I cannot say. I haven't been to the airport since the pandemic. But in this instant case, so for Tachibana's rules of conduct, along with improper conduct, includes discourtesy in any form of disrespect, rudeness, or otherwise unprofessional behavior to Tachibana's customers or employees that negatively reflect or result in the loss of goodwill of Tachibana or its affiliate
And
companies.
what happened in terms of the Gold Lane incident? She complained to somebody after that? Is that what the complaint was?
What happened was on February 21st, Tachibana received a complaint from its business partner, its customer,
And when
JTB,
was she
that
notified of that? When was she notified of that?
I am unsure off the top of my head when she was notified of it, but given that she
I'm
was
looking at the
requesting,
hearing, and it sounds like she may not have been notified until, a couple days before the March 16th meeting.
so regardless of whether she knew about that specific incident, the fact is that when Ms. Choi was hired in 2016, she received 3 months of customer service training and had received multiple customer service complaints since 2018 and verbal warnings about that.
But
what happened?
your client was very clear in the hearing that they weren't relying on any previous incidents, and they were only relying on the 2 February incidents and the refusal to sign the acknowledgement.
Yes, and for this February 17th incident, JTB complained to Tachibana that Ms. Choi's actions and behavior were problematic, and that Ms. Choi had an angry and upset attitude in front of tourists many times in the past. And again, she should have known about the TSA Gold Line rules, given that her position required her to be at the airport and up to date on TSA regulations.
Okay, and in terms of the hearings officer's decision, it does say that the employer has, and the law does require the employer has the burden of proving misconduct, but it was the employer's prerogative to apply progressive disciplinary action and ultimately discharge, right? But when I look at the only written warning, it says this is on a JTB form for Tachibana Enterprises, because Tachibana Enterprises is owned by JTB, correct?
Tachibana is owned by JTB, but
I understand Tachibana does work for other companies also.
Yes.
That's in the record. But it says this is the progressive discipline, according to this form: counseling, a verbal warning, first written warning, final written warning, suspension, termination. This is indicated to be a first written warning, and this pertains only to the refusal to sign. And the termination notice that was later issued on March 30th says that she is being terminated based, and it says prior disciplinary action within the last 2 years. This is one of your client's company's forms, so it looks like they were looking at a 2-year period, and it says termination effective March 30th, prior disciplinary action, verbal and written warning, correct? No final written warning, no suspension, correct?
Yeah, that is not checked off on the notice, but again, in the written warning from March 16th, it does state that further disciplinary action may be taken for any violation of any other policy or procedure. And given that Ms. Choi was directed to sign the handbook acknowledgement form as soon as possible and admittedly failed to do so, that constituted insubordination and violation of the handbook rules of conduct, and the fact that her behavior in February garnered 2 customer complaints from key business partners.
But your form says follow-up date April 14th, and it seems to have a choice of 30, 60, or 90 days, and she was not given the 30 days, correct?
That is what the form says, and that is what the hearings officer addressed. And again, that is...
Let me ask you this. You know, I look at our case law. I look at the choking employee in Maderos. I look at the CDL tour bus driver who didn't have insurance in the Keananini case from the ICA. I look at Hardin, who was the chronic absentee woman. In all those cases, they knew or should have known that their conduct could, merit termination or place their job in jeopardy. What evidence is there here that Ms. Choi knew that, going through the TSA line or trying to change a seat in a certain manner would place her job in jeopardy?
The notice she had was her years of training and work with Tachibana. Again, she received 3 months of customer service training after she was hired, so she understood how important customer service was for Tachibana and its business partners.
But in this, that's not very specific to this particular thing. Couldn't the other side make the argument that this is just, sort of good faith efforts, there's sort of discretionary acts on the employee, and that this doesn't rise to the level of misconduct connected to work?
For misconduct directed to work, so it's gross neglect of duty and also failure to obey a directive from the employer. Here, she knew customer service is very important to Tachibana. She stated multiple times she would try to provide the best customer service. However, the employee handbook states that if employee has a disagreement with a directive, they're to bring that up with their supervisor out of sight of the customers and the guests.
Well, you know,
And
I understand the point that, well, maybe her true clients or Tachibana's true clients might not be the people who were in line, but she was acting for those people in line, those people that she was tasked by Tachibana to assist. She was using her best interests, it seems. So I'm just trying to understand the aspect of intent, which is one of the factors, which is really squarely in those cases I cited.
so under HAR 12-5-51E, you can still find misconduct if there's employees' gross neglect of duty, so whether they intended to or not. In this case, regardless of her motive for the actions, it resulted in complaints from Tachibana's customers of JTB and Japan Airlines.
The
A good
the issue really here is whether or not this meets the standard of misconduct under the unemployment law, correct?
Yes, in determining if the circuit court was correct in applying 91-14G. And in this case, when Japan Airlines complained, so basically, again, to summarize the 2020 incident with the customers taking too long, I believe we talked about that, just to provide more details. So what Japan Airlines complained is that Ms. Choi raised her voice and angrily told a Japan Airlines staff that they were taking too long to check in her customers, and the customers were upset. When Japan Airlines manager went to apologize to the customers stated it was no problem and that they were not upset. Japan Airlines then complained to JTB, who complained to Tachibana, and asked Tachibana to provide good service to its customers, help maintain good relationships between JTB and Japan Airlines, and they pledged to Tachibana to never break JTB's good relationship with Japan Airlines because of Ms. Choi's behavior. So this conduct...
Well, didn't it end up, just as a reminder, it said remind claimant about acting appropriately to maintain good business partnership relationship. Wasn't that sort of the context in which the so-called complaint was made?
The problem for Japan Airlines and Tachibana was how she handled it, because she addressed the issue in an angry and upset attitude. But for this Japanese company, Japan Airlines, and Japanese customers, they believe things must be addressed calmly as possible, because that is part of their standards for customer service.
Was that part of the evidence?
It was not part of the evidence, but it is inherent in the rules of
Let's not get
conduct.
into that then.
But it was, again, it was part of the record that Ms. Choi had an angry, upset attitude, and that was complained about in both the complaints about the Gold Lane incident and the seat change incident on February 20th.
Can I ask you about those two incidents? You know,
Yes.
in the testimony, I think it was by Ms. Mizuno, she said that the two complaints were the final warning, and that was her words, final warning. Were there any incidents after that? Because I had asked Mr. Collins the same question.
To my knowledge, no, not on the record of appeal. So it was the three incidents where the
No,
February
I understand what
7th
the three are, but
Yes.
the two complaints, the JL and the TSA line, Ms. Mizuno said that was the final warning. That was her words. Was there anything that happened after that?
So just quick note, in the SRO proceedings, JTB or Tachibana was not represented by an attorney, and they also had to have Japanese translators for some of the employer witnesses. For this case, it was just the February incidents and the handbook incidents. And so because, again, although this was not brought up in the record of appeal because it was not asked, by the end of March is when Tachibana completed investigating the claims from JTB, Japan Airlines.
So that's not in the record. The record to me is a little bit unclear as to when your client was notified as to the Gold Lane complaint and the JT JAL complaint.
Yes. Tachibana was told of the TSA Gold complaint around or about February 21st, 2020, and they were notified the next day of the Japan Airlines incident on February 22nd, 2020.
Were written warnings issued subsequent to that as to those two incidents?
No, and it's not on the record because, again, the investigation was not completed until the end of March. And as stated in Tachibana's rules of conduct in its employee handbook that Ms. Choi had when she was hired, that any violations of the rules of conduct could be grounds for discipline up to including termination. So while they have this procedure written out in this written warning, it is up to the employer's discretion per its own policy.
Okay, but going back to the testimony, you have a final warning, but nothing bad happens after that. But the next thing that happens to her is she's fired. How does that add up?
Because part of it took, as Tachibana testified, it took it as progressive discipline because she had a written warning and a directive to sign the employee handbook.
But Ms. Mizuno said the two incidents were a final warning, whatever that means.
I think
to me, that means that's it, no other chances. If you do something else after that, but nothing else happened.
So what happened was she was the only employee who failed to sign off the employee acknowledgement.
But they said she had to the end of the month, and you fired her on the 30th. She couldn't get to the 31st. That doesn't add up to me. And then the written warning says April 14th. It's all inconsistent. It's all over the place.
Well, again, the hearings officer had the opportunity to address that. It appears
He never explains how he reconciled all of that. I have no idea how he got there.
I cannot testify to
That's part of the problem, and that's part of the problem for me.
They're not here to testify today. And again, it is Ms. Choi's who carries a heavy burden to make a convincing showing the decision is invalid. So, but after these three incidents that each violated Tachibana's rules of conduct, they decided it was grounds for termination for progressive discipline. And these issues were discussed to the extent as we discussed today below Department of Labor and Industrial Relations.
Ms. Choi did raise, the hearings officer doesn't include it, but apparently in the initial unemployment hearing where the unemployment division granted, where your client initially did not appear at the first hearing, correct? And she was granted unemployment. At that time, she apparently raised COVID issues. The fact that, the guys were being told that they're not to expect much work. And they don't talk about this at all. The hearings officer doesn't, but as of March 25th, the state was closed. There was not going to be any Japanese tourists coming to Hawaii from March 25th, correct?
So again, that would be yes, the state was effectively shut down around that time. However, the motive for Tachibana's termination of Ms. Choi is a question of fact that is subject to the clearly erroneous standard. And here, over the past 5, almost 6 years for this unemployment proceeding, she has not denied at Asaro, the Circuit Court, the ICA, that on February 7, 2020, she was told she had to sign the employee handbook acknowledgement form and that she refused to sign it. And
I'm sorry, I want to ask you about that. Now, let's say an employee has a legit reason not to sign the employee handbook. Mm-hmm. I mean, is that going to be still insubordination that rises to misconduct?
Under Tachibana's policy, even if an employee objects to a directive, they still have to comply and then discuss their disagreements with their supervisor or human resource individual out of the eyes of tourists and other customers. So under Tachibana's policy, yes, that would constitute insubordination.
So even if you had, say a company had just a bizarre employment policy that perhaps said, hey, look, we got the right to search your iPhones anytime we want. And the person has, whoa, I'm not sure if I want to sign this. Maybe they meet with the HR department. The company still insists you got to sign this. Not signing would still be insubordination to merit misconduct?
In this case, that was not an issue. What Ms. Choi took at issue with was the at-will provision in the employee handbook that was in there when she hired on. And Ms. Choi understood what the at-will provision meant, for she translated it several times across the record of appeal, as basically meaning she may be terminated at any time for any reason or no reason. However, because she was an at-will employee, she too was free to quit at any time for any reason or no reason. So another thing Ms. Choi had failed to deny over the course of these proceedings is that she was aware that the Gold Lane rule changed and it was for business class passengers only. And she also, third, admitted that the complaint was made against her by Japan Airlines. And four,
So it was for business class passengers only.
correct, that is what the Gold Lane is for. And the passengers with the baby she attempted to bring to the Gold Lane did not have a business class ticket. And again, the problem was not that for JTB, it was that how her behavior was. How she acted angry or upset, and that is in violation of the rules of conduct for any disrespectful, rude behavior.
Counsel, I want to ask you one question, though. So I understand the factual things that you're trying to get at. You know, a lot of the discussion, though, seems to me to be about the standards that we should apply. I hear a lot about like progressive discipline, and I hear about issues that almost sounds like, was she properly terminated? The question here is under the statute and the regulation. So I want to hear your argument with specific to the statute and the regulation based on the facts that you claim are uncontested by Ms. Choi.
So again, while we take no position whether she receives, this secondary appeal has a high burden for Ms. Choi because she has a duty to make a convincing showing decision is invalid, unjust, and unreasonable, even though it's presumed valid. From Tachibana's stance, her conduct constituted misconduct, and under the statute, misconduct disqualifies an employee from unemployment insurance. But again, it is up to the DLR to determine how to apply its rules. Lastly, over the past 4 or 5, almost 6 years, Ms. Choi failed to deny that she received a written warning on March 16, 2020 for not signing the acknowledgement stating the written warning stated she would be disciplined if she continued.
Sorry, can I just ask you, what was the date certain by which she was supposed to sign that handbook acknowledgement?
If you like the exact page number, the exact number is Record of Appeal, page 109. It does state she should comply. The follow-up date would be April 14th. However, she was directed multiple times that she should sign the acknowledgement form as soon as possible. And
Okay, so she had time until April 14th. Is that your position?
Our position is that she had to do it as soon as possible, and that by the end of March, she was the only employee who failed to do so.
Okay, as soon as possible, but no later than April 14th.
That was just a follow-up date because, as the written discipline notice says, any further policy violation may result in disciplinary action up to including termination. In this instance, by the end of March, she had 2 policy infractions with the...
I understand. Thank you.
Another point that was brought up was the language access below. So for this case, actually the record shows Ms. Choi did request a Japanese interpreter. For the exact record site, it would be the Asara Record of Appeal, page 36, line 1 to 20, and also on page 121.
Is that the hearing?
That is one of the hearings, I believe. There's also reference to that and the ICA docket 21 at page 13, ICA docket 27 at page 5 through 8. So at the first Asaro hearing when Ms. Choi appeared, they provided the requested interpreter service. And then during these proceedings, the interpreter and the appeals officer asked Ms. Choi multiple times to speak 1 sentence at a time. But despite these reminders, she would speak multiple sentences at a time and often too fast for an interpreter to keep up.
How do we know the interpreter's qualifications, by the way?
The qualifications were not in the Record of Appeal, but they were provided by the state. So I do not know the interpreter's qualifications off the top of my head. I just know that it was provided.
It appears to be some kind of telephonic service that was called.
It appears to be a service that the Asaro office contracts with provide. So
The person's the interpreter identified herself by her first name and not her last name.
yes, and in the circuit court proceedings, we did have an identification of first and last name. But Ms. Choi's decision to not follow instructions and speak too fast and too many sentences at once does not indicate an abuse of the agency's discretion. Similarly, at the circuit court proceedings, for example,
In terms of vital documents, opposing counsel appears to be arguing that the notice of the new hearing, the first hearing that she didn't appear for, was something that should have been translated.
Although he states it should have been translated, he has not pointed to an exact statute stating that all documents must be translated.
It says
into
vital documents, so I'm just wondering what
vital
vital documents are. What is your position?
That would be for the respective agency to determine, because part of the standard requires that they do what is feasible for the agency. And at this time of COVID,
At the first hearing, did she have an interpreter?
I am not
The
aware.
one that your client did not appear?
I am not aware if she had an interpreter. My client did not appear. However, Ms. Choi did understand the notice because she was expecting a call, because she called up the unemployment office, was able to connect despite the many calls they received during the COVID-19 pandemic. But she just misunderstood and thought that they would call her rather than the fact she had to call in. And
Where does that appear in the record?
I cannot recall the exact transcript, but it was discussed in the, apologies, let me pull up the date for you. They did discuss it in the record of appeal, I know, around her request to appeal, her request for first opener, which would have occurred on July 24th, 2020. Because she stated in her reopener request that she did not realize that she had to call in herself because she called the office and mistakenly believed that they would call her. But regardless, she was able to understand the notice such that she requested the reopener. And at the circuit court proceeding, she had a Korean interpreter as requested. Circuit court proceeding, for example, on March 22nd, 2020, she was provided a Korean interpreter. Apologies, I'm going to mispronounce this. Jung-Shin Oberlin was present there at her request. At the end of the hearing, Ms. Choi confirmed on the record and stated in the court docket that she was satisfied with Ms. Oberlin as her translator. Thereafter, on the hearing for circuit court on April 1st, 2020, Ms. Oberlin translated for Ms. Choi for approximately 1 hour and 14 minutes. So therefore, she had language access. And again, for this case, again, it is to be decided based upon the statute 383 for unemployment. It is not an employment discrimination case or a national origin discrimination case. At this time, unless the court has any other questions, Tachibana has nothing further to add, and we will rest on the briefs.
Thank you.
Thank you, Your Honors.
Any questions? Hearing none. Mr. Collins, would you like to take an opportunity to consult with your client, or? Yes.
They also assist other companies, but they're part of JTB. They were bought by JTB. So our position is that I don't believe that they really are a customer in terms of a customer service complaint. They're just the parent company or the senior division. But I can't, there's nothing, I can't cite anything other than what I consider to be the definition of a customer that wouldn't include a parent and subsidiary company. So I don't have anything.
Well, his testimony went further than that, but so be it. Yeah.
Yeah. And then of course, JAL isn't a customer of Tachibana, and so their complaint it's not really a customer complaint. It's I guess it's like a partner complaint. In this about the employment manual.
Does it really matter if it's a customer or not? It's a complaint about her conduct that was received that Tachibana was acting upon.
Yeah, it only matters to the extent that the hearings officer was not correct, that it wasn't a customer complaint, and he was basing his decision on supposedly these multiple customer complaints.
So that's clearly erroneous. Where does that really get you, though?
Well, then there's nothing to support the misconduct connected with work finding. I mean, if you start
still her conduct being questioned,
it's true,
and it's reflection on the company, and the company not being happy with it.
That is correct. But in terms of what's supporting the hearings officer's decision, it's there.
The issue really is whether or not that constitutes misconduct, correct?
No, and our position is it isn't. And with respect to the employment manual, this is an important point that I overlooked in the opening, is it's important to note that, first of all, the handbook is only written in English. And on March 3rd, this is in the record on Appeal 154, Ms. Mizuno sent an email basically saying, we will no longer accept communications in any language other than English. If Ms. Choi wants to speak, do not accept anything. If she wants to submit things in another language, she can have it translated. So I think that that's an important point because, the issue with the handbook, I understand the hearings officer's finding was, well, the 2012 and the 2020 handbook are the same, but if there's a custom in usage going on in the employment context between 2012 and 2020 that was at variance with the handbook, signing this new handbook would have some significance other than just acknowledging. And so Ms. Choi, it's clear from the record she didn't understand. She had concerns about the new handbook and that her questions weren't being answered. And then at some point they said, well, we're not going to communicate with you anymore, even though everybody apparently speaks Japanese at this company. We won't even speak to you in Japanese. So I do think that the employment manual, there just isn't evidence in the record to support anything other than perhaps a good faith disagreement or technical compliance issues.
Counsel, did you pick up during that first hearing that Ms. Choi wasn't present at, that the hearings officer wasn't enforcing the witness exclusionary rule for part of the hearing, that everybody was in the same room, they could all hear each other, and then finally it dawned on him, I think, when Sammy Lee, if I got the name correct, started talking, and he realized they're all in the same room. Did you pick that up?
Your Honor, I think one of the problems, and this goes to our procedural issue, is that I think he also asked, or Ms. Mizuno represented, that all of these people were representatives of the employer, and this goes to whether or not the hearings officer should have been leading the examination in the first place. But yeah, I don't think that all of these witnesses should have been there, but the hearings officer also shouldn't have been conducting the examination. I mean, if you exclude everything that the hearings officer asked in terms of questions, the employer didn't put on any evidence. It was all elicited by the hearings officer. And in the context of a sole proprietor and an employee, they're both unrepresented, and the rules provide, and that happens in trial courts all the time where you have pro se litigants on both sides. But in the instance where you have this company who has representatives and the rule says that it's only supposed to be for unrepresented, it's a problem. I also wanted to note that you
usually designate one representative and the others that are witnesses stay outside. Isn't that how those agency hearings usually go?
Yes, that's usually how they go. So it is. I mean, that's another procedural error. And in terms of, the burden is on the employer to prove the misconduct connected with work. That's the burden. And so if the employer doesn't prove that and there isn't substantial evidence to support a misconduct connected with work finding, then the unemployment insurance benefits should go to the worker, because that's the purpose of the law. It has a humanitarian purpose, and it should always be liberally construed in favor of the former employee. One other point about the vital documents. The unemployment office, I know this personally because I file my unemployment taxes quarterly. Their website is translated into like 100 languages. You can pay your thing, you can make your claim in 100 languages, but for some reason, all of this information is relatively standard notices, the 91-10 notice. I mean, the only change would be names and a few things. I can't explain why are these documents not translated into all of these languages, that their website's in 100 different languages. Why would this document, which is very important to let an employee know that, your benefits may be challenged and here are the reasons. The issue of her not calling in, I think she's clearly stated it in the record, that she didn't understand that she had to be the one to call in, and there's stuff that's not in the record about this issue, but it is an issue that, I think the judiciary is a model in terms of language access. DLIR is pretty good on a number of levels, but this particular issue, that the record shows a total failure to comply with the statutory language access requirements. And there's really no reason, particularly for ISARU, that deals with this all the time with many people that have limited English proficiency, why they can't have these 91-10 notices and your further appeal rights notices, these standard forms, why they can't be translated, which are vital for people's benefits, why they can't be translated so that individuals have as clear an understanding of what they need to deal with in these processes. So we ask that this court reverse the lower courts and reverse the hearings officer on the misconduct finding and order the DLR to provide Ms. Choi her entitled benefits, and to provide guidance regarding language access in quasi-judicial proceedings, as well as the standards of conduct for the hearings officer with respect to when an employer is represented by an agent. Thank you very much.
Thank you very much, counsel. And this court will take this matter under advisement.
Ku Ilona, please rise.
Ua ho'oku'u ia mai ne, kea aha ho'okolokolo ki ike hanohano o Komoko Aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.